In terms of employment law development over 2014, and in the context of the employment law review, it's probably best to describe it as something that is strictly conducted, with a quick, slow. So there's definitely a sort of a double approach to it in terms of pathway, and I'll touch upon that as we're going through it. So just in terms of contents, we'll look at the developments in 2014. There have been 13 statutory rules over the last year, which is, it's double nearly of what we had last year. We had around half a dozen statutory rules regarding employment law in 2013. A lot of them very technical, very anaraging, as Scott would say. And he said to me, I'm under strict instructions not to bore you with the details. So what I do is I focus on the ones that HR practitioners and employment lawyers are probably more focused on. So 13, which is quite a number. One statutory instrument, which is a national minimum wage increase. National minimum wage always gets a sort of a, there's 1st of October, it comes and goes. But it is a big issue, it is a big area, and there have been significant reforms in this area from a statutory and a case law perspective, and trade unions are actively pursuing very stringent strategies with regard to national minimum wage, and I'll talk to you a wee bit about that. We'll talk about the progress on the draft employment bill. Nobody has had sight of the draft employment bill, it has to be said. So what I've had to do, along with my colleagues, is essentially trawl our way through the Hansard up at the Northern Ireland Assembly to see exactly where the government's thinking is on various issues with regard to the employment law review. And you'll remember, and I know a lot of the faces in the room, you'll remember this is an issue that has harked back to the 23rd of November 2011, when I nearly crashed my car on the way to Legal Island, Ramada, when Vince Cable made all these announcements about employment law reform, and yet again my notes were out of date. So we're still dealing with the hangover and the fallout from that particular announcement. And then we'll look at the developments of the employment law review. And it's perfectly understandable from a practitioner's perspective to say, well, what's the difference between the employment law bill and the employment law review? And the difficulty is this. There are things that sit outside the employment law review that weren't in the original review but have sort of been shoehorned into it or sit alongside it, and it's very difficult to see exactly where you're going with these reforms. And hopefully through the course of this morning I'll be able to steer you in the right direction in terms of this is going to happen, this isn't going to happen, there's a question mark over this. So that's essentially what we're looking at. So as I said, during the year, most of the statutory rules that we saw were quite technical in nature, and others were the usual suspects in terms of rates and statutory maternity pay, etc., etc. The first one that was in February was the employment rates increase in limits order, and that came into effect in early February. And the thing to remember here is, if you're a HR practitioner with a sister body in GB, remember that the calculation mechanisms are different. So we are in Northern Ireland, we are slightly out of sync in terms of pay limits and in terms of the caps on unfair dismissal compensatory awards. So we're out of sync. So don't fall into the trap of just cutting and pasting what's happening in GB in Northern Ireland. Those rates are different, although there's mechanisms in place that bring them back into line. But as we stand, the cap on a week's pay stands at £470, guaranteed pay is £25. The unfair dismissal compensatory award is £76,600, okay? And that is a big issue at the minute, because when people talk about compensatory award for unfair dismissal and you see that figure, the 76,600, it's a massive figure. Practitioners who have been unfortunate enough to be before an industrial tribunal on an unfair dismissal case will know that cases never get to that extent, And that was one of the primary motivations for the coalition government across the water to say, we need to now manage claimants' expectations if they take an unfair dismissal case. So what happened across the water, as we know last year, was that the limit on compensation award for unfair dismissal will either be a year's salary or the £76,600, whichever is the lower, in order to manage those expectations. And when you consider that most unfair dismissal claims as a standalone jurisdiction in Northern Ireland settle for around £5,500 to £6,000, you can see the coalition government's motivation to do that. But that has not been replicated in Northern Ireland. So we are still working with the 76,600, and it's not the lower of a year's salary. So it's important to make that distinction. In March, the national minimum wage variation of financial penalty came into effect, and that's quite an interesting development because it effectively says now that for every national minimum wage infringement where an employer isn't paying an employee per infringement, the financial penalty is raised from £5,000 to £20,000. Okay. And in the health sector, particularly at the minute, this is a bugbear. Okay. The trade union Unison are launching a very vigorous campaign, especially with regard to home care workers who are travelling between houses looking after people who are on their particular road. Okay. 93% of the councils that were asked about this in England and Wales said they had no idea whether or not the home care provider paid their employees for the travel time between their clients' houses. Okay? And the reality is the vast majority of them don't, and they should. And the argument is now that they should be, because that is travel time for the purposes of the working time regulations, so it's working time. Therefore, it attracts a national minimum wage. And now suddenly, thousands of these care workers are finding that they're falling below the national minimum wage because they're not getting paid between travel time between the houses. And now, this is where these penalty issues will be a big issue because it's £20,000 maximum fine per infringement. So if you're in that industry, you'll probably know all about this, and you're probably looking at your pay issues there as we speak. But it's something that you perhaps should be aware of. The public interest disclosure prescribed persons amendment order. This is a perennial in the sense that every 2 or 3 years we see that the list of prescribed bodies that someone can blow the whistle to is added to on a relatively regular basis, as I say. So we have 8 new organisations being added to this, and again the focus seems to be on the health sector. So the General Medical Council, the Nursing and Midwifery Council, and around 6 or 7 other bodies have been added to that list. And folks, I rattled on about this last year, and it may have been prescient, it may not have been, but in terms of whistleblowing policies, if you don't have one, you need it. You absolutely need to formulate one, because this area of law is going to change. I'll talk about that in a minute. But effectively, what this amendment did in April was to add to the list of the bodies, the prescribed bodies. Okay, and the important thing to remember about public interest disclosure legislation, and I wireless about this a wee bit and rant about it. It is a piece of legislation that is reactive in nature and remedial. Okay, in other words, it happens after the event, and it's about detriment and dismissal protection for an employee who blows a whistle. The whistleblowing legislation is not proactive and preventative in nature. Okay, so it's not enough when you're formulating a policy internally in the organisation to look at the legislation. The legislation will give you a wee bit of guidance in terms of what is definite and etc. But the reality is your whistleblowing policy, you just need to know that the legislation is in the background. It does not dictate what the content of your policy should be on whistleblowing. Okay. Also on the 6th of April, the Social Security Benefits Operating Order came into effect, which increased statutory sick pay to £87.55, statutory maternity pay to £138.18. Okay, and again, it's the usual suspect. And lo and behold, that should be the Employment Relations Law Order 1989, another 9 there, Blacklist Regulations 2014. Again, a contentious area. Since 2010 in GB, we have had blacklisting legislation. So in other words, it is offence to compile, use, sell a list of people who are trade union members, activists, militants if you like, and sell that on to another organisation or pass that on to another organisation. Now this was as a result of the Consulting Association case back in 2009. GB brought it in because the power has been in legislation since 1999, both across the water and here. It only came into effect in April of this year. And be very careful from the HR practitioner's point of view. If you're compiling lists of employees, make sure it does not inadvertently contain lists of people who are solely trade union members of one particular trade union, because you might get accusations that it could be perceived as being a trade union blacklist. Okay? The regulations are very, very tight on it. They're very tight in terms of what constitutes a blacklist, so be very careful about that. The remaining statutory rules, and we're not going to go through them, they're in your packs and you can go through them in your own time. Technical reforms to gangmasters legislation, the maternity allowance in self-employed context, a few amendments to the rehabilitation of offenders, these are exception questions, changes to immigration penalties, and interestingly, here's the thing, the revocation provisions regarding statutory sick pay records and reclaiming. Okay? So most of you in the room will know, if you work closely with payroll, etc., if you have someone who's off on long-term sick and they go over the 13% threshold of the national insurance contribution, the employer has the ability to claim that back. Okay? That has been revoked. That has been revoked, and the record provision has been revoked since April. Okay? And if you're a CIPD member, you're probably thinking, oh yes, the sole reason why this is happening is to provide the funding for the imminent health service, health and, what's the name of the organisation? It's gone from me. It's Maximus as a company, but it's an occupational health service that will kick into effect late this year and be phased in England, Scotland and Wales. When someone is off on long-term sick for over 4 weeks, they'll be automatically referred to occupational health. Okay? Health and work service, that's where it is. Give them the name. There's no sign of that service being brought into Northern Ireland. There's no indication that that service will be replicated. The Department of Social Development, absolutely quiet on it. DHSBS, silent on it. Nobody knows what's happening. So in England and Wales and Scotland, this is being rolled out late 2014, early 2015, eventually throughout the country. Okay? Right the way through. But there is no sign that's going to happen in Northern Ireland. Yet, the legislation that's providing the basis for the finance in Northern Ireland is being repealed. So there's a bit of a lacuna there, there's a bit of a gap in the legislation. We have absolutely no idea why that is happening, because we've been given no indication that that Maximus company provided health and work service will be extended to Northern Ireland. So a bit of an unknown there. In terms of statutory instrument, our usual suspect was the National Minimum Wage Amendment Northern Ireland Order, or regulation, sorry. It increased the adult rate to £6.50. The 18 to 21-year-old rate increased to £5.13. Those up to the age of 18 at £3.79, and the apprentice rate now stands at £2.73. Okay? Again, a massive political issue. A massive political issue, because not only do we now have the legislation in place for naming and shaming employers who fail to comply with the national minimum wage, not only do we have an increase in the penalty for failure to abide by the national minimum wage, but we also now have a lot of pressure, especially in the third and voluntary sector, about the living wage. The living wage, which is a concept, a voluntary concept, where more and more organisations are signing up to it, especially in the southeast of England. It sits currently at £7.85. And if you want to really put the frighteners on, the London living wage stands at £9.15 now. Okay, so there's a significant difference between the London living wage and the national minimum wage. Okay. In terms of the pending employment bill, nobody has seen it. Nobody has seen it. So, to a certain extent, there's a bit of guesswork going on. There, as I say, we had to trawl through Hansard to see what was likely to happen and what was likely not to happen in the areas of reform which were announced by Vince Cable back in November 2011. Okay. What is obvious is that there has been a degree of, let's say, horse trading between the social partners in terms of what's coming in and what's not coming in. And again, it only re-emphasises the difference in Northern Ireland and GB in terms of where we're going. Okay? Some areas that fall out of the review, outside the review and the bill, are 0 hours contracts. Now, there is an indication that 0 hours contract may be contained within the bill. At the Employment and Skills Committee on November the 19th, not that far away, the results of the 0 hours consultation should be known. But if you look at the website of the Assembly, it says TBC, to be confirmed. So we're not sure about this. But I can tell you, I'm going to address this in a second anyway with regard to 0 hours contract. 0 hours contracts are here to stay. There's not, a ban is highly unlikely. The only area that looks like it's going to be regulated is exclusivity clauses. I can have a fair guess that I could count on one hand the amount of organisations here in Northern Ireland who have an exclusivity requirement for their 0 hours contract. But do not be under any illusions about 0 hours contracts as a topical issue. My organisation is facing more and more inquiries now from people who are on 0 hours contracts who are phoning us and saying, my contract's being terminated as part of the austerity package in the organisation. But I've been here for 10 years, I'm constantly offered work, I never turn it down, I can't appoint a substitute. I'm told what to do and how to do it. I abide by the internal rules of the organisation. You know, All of those point towards what would be characteristic of an employment relationship, not a 0 hours independent contractor or worker relationship. And that's why we call it a slow burner issue. 0 hours, don't worry about exclusivity or penalty clauses or transparency issue. 0 hours will become an issue now because people will look to actually say, do you know what, I have been mislabeled over the last 15 years because I am a de facto employee. Okay? So a big issue. Chippy reform, I'm not going to touch upon because Mr. Chippy himself is in the room, but what I can say from a Northern Ireland perspective is this: it is politically very sensitive. Very sensitive. You hear all sort of sporting analogies that are used with regard to Chippy, and the one that I hear most often is kicked into touch, to use that rugby terminology. So there has been virtually nothing said about Chippy, and I'll come back to that in a second. Okay. What's not changing, and we're pretty certain about this, but everything's caveated, but what's not changing? The unfair dismissal qualification period is due to stay at 1 year. Okay? So last year we sort of hemmed and hawed about it, we didn't know. We have a fair indication that the stakeholders and the Minister is off, to use that oft-used term in the Assembly, the Minister is minded to keep unfair dismissal qualification period at 1 year. Okay? So that obviously it's different for over 2 years now. In GB, it's been sitting at 2 years. The bottom line in all of this was there was no evidence to suggest that increasing the unfair dismissal qualification period to 2 years would stimulate the economy or give the small to medium-sized employer a bit more confidence in terms of employment because they needed to get rid of someone after 23 months. Okay? The evidence wasn't there. And so the argument then was put to the Minister, are you going to legislate on the basis of perception? Okay? And the answer is no. So it looks very clear that the unfair dismissal qualification period will stay at a year. Yet again, if you have a presence, your company has a presence across the water, that's going to be a key difference between them. The unfair dismissal compensation basis, as I alluded to earlier on, will stay the same. So we still have the same statutory framework in terms of how unfair dismissal compensation is calculated. It will not be the lower of a 1 year salary or the cap at 76,600. Okay? The 1 year salary component is not coming into effect. It has been in effect for over a year in GB, so that is up and running. Okay? Compromise agreements. Okay? Probably the vast majority of people in the room at some stage will have been involved in either facilitating a compromise agreement through a solicitor or through the offices of the Labour Relations Agency. They are relatively straightforward concepts. The agreements are relatively straightforward. In England and Wales, however, there was a great pressure to simplify them, okay, to make them a bit more straightforward, but to also incorporate within the context of saying goodbye to an employee without fear of having litigation against you at a later stage was the whole notion of protected conversations. Okay? Protected conversations name changed throughout the course of the last sort of 18 months, and the last time we heard about it was unadmissible offers of settlement. Okay? And you should have known with a title like unadmissible offers of settlement that it was going to be complicated. Our sister body in ACAS, in England, ACAS, they have got this provision for these inadmissible offers of settlement under the guise of protected conversations. And the guidance for HR managers and line managers is 88 pages long about you can say this, but you can't say this, and do this, and make sure you don't do that. And remember, it only covers this jurisdiction and not these other 64 jurisdictions. And it is a complete and utter mess. Employment lawyers and HR practitioners alike were saying it will be unworkable, it's impracticable. Okay? In fairness, the Minister has heard that argument here and has decided that this notion of changing compromise agreements to the term settlement agreements and providing for inadmissible offers of settlement were unworkable and therefore they're not coming into effect. So again, significant differences there in GB. Okay, because GB has 2 year unfair dismissal qualification. The unfair dismissal compensation is different because it's set the lower of wages or the statutory cap, and they have settlement agreements with these protected conversations. We will not have those. Okay, so you're either in the room now breathing a sigh of relief, or you're really frustrated, or you're going to have to get onto your counterpart in GB and say that we're on a different road. Okay. What is changing, and it's clear that it's changing, is early conciliation. And my organisation is obviously at the forefront of this. It is the centrepiece or flagship, if you like, of the draft employment bill, as we're told. because it was the one area where stakeholders agreed that, yeah, it will work. From a practical perspective, it simply means a change in the sequencing. So an employee wants to take a case to an industrial tribunal, they will have to come through the offices of the Labour Relations Agency to be offered conciliation. Okay? And it'll either work or it won't work. If it doesn't work, they get a receipt, they go back to the industrial tribunal and they lodge the case. So it's not a mandatory requirement to conciliate, okay? It's a mandatory requirement to consider the possibility of conciliating, and if it works, and if it doesn't, it doesn't, okay? Great in theory. One of the big difficulties with it is, as we saw with the fixed periods of conciliation that existed a few years back, time frames, time limits. We've already been 2 cases, Thomas against Nationwide and Beale against Action, both to do with time limits. One to do with multiple respondents of Tubi transfers, and I'm sure John's well versed in that, and the other is to do with a flaw where the employee assumed that they were exempt from going through early conciliation. So already we can see cases starting to come through with early conciliation. We're watching those very, very closely to see what the impacts are. We recognise the difficulties with regard to time limits, etc., and we know how tight the tribunal chairs are about timetables, time scales, so we'll be watching this very closely. But it's one of the areas that the social partners have agreed upon. It is the centrepiece of the employment bill, so it will be happening. Okay, it'll be in the bill whenever we see the bill, either tail end of this year or early next year. Okay. Neutral assessment, another form of alternative dispute resolution. The power for the agency to offer neutral assessment will be contained within the bill, but it will not be automatically become the law straight away. This is what we're led to believe. Neutral assessment is where conciliation has perhaps failed, and rather than go on straight into arbitration or to industrial tribunal, we can offer neutral assessment where the parties can sit down and an independent arbitrator stroke neutral assessor will give their professional opinion that if it were to proceed to an arbitration, this is how they view the case is going. Okay? So it has its attractions, it certainly has, but the difficulty is, and me being the eternal cynic, I can see the potential for it to be abused by either side, for people to better realise their negotiating positions, and there's a lot of detail to be worked out. So I think that's one of the reasons why the power to bring in neutral assessment is there, but it's not coming in automatically because there are a few things still to work out. Okay. Collective redundancy consultation will change. Okay. Now I can tell you, see, for the last 3 weeks up on the Hill, there have been massive amounts of lobbying by the trade union movement in this area. Okay. But to no avail. For large-scale redundancies involving 100 people or more, it will be reduced to 45 days. And fixed-term contracts, FTCs, cannot be used in the calculation. That is a mere reflection of what happened in GB last year. Okay, so from a HR practitioner's point of view, and you have a presence across the water, it's good news because you have consistency of approach. But be aware that that is not the end of the story with regard to collective redundancy consultation, because there are still lots of question marks hanging over. Next Thursday we'll have a decision from the Court of Justice of the European Union on the well-known Usdaw case, the Woolworths case, as you'll know, in terms of what constitutes one establishment. Okay? That will have a major impact on how collective redundancies are approached. And secondly, we're still waiting on a decision in the Nolan and USA case to find out when the employer's obligations to trigger the consultation process actually begin. Okay? The best way to describe the law on collective redundancy consultation at the minute is it's still in a state of flux. Okay? This is a significant change in terms of the mechanics going from 90 days to 45 days and not including fixed term contracts. But there are still a great amount of unknowns. Hence, the Labour Relations Agency, we've had a draft code of practice in this area for about 3 years, and we can't commit it to ink yet because the law is in such a state of disarray. Okay. In terms of whistleblowing, and it's a hobby horse of mine, you've probably gathered, again, going to change. It looks very likely that we're going to mirror the reforms that happened in GB in June 2013. So if an individual employee or worker is going to blow the whistle on the employer, it must genuinely be in the public interest, and that will be defined. So the purpose of this is to close what's known as the Parkinson-Sodexo loophole. So if an employee, as an individual, has a complaint about their individual contract of employment, they will not be able to have that as a valid protected disclosure because it relates solely to them. It's not in the public interest. Okay? And this has been a complaint from employers and employers' bodies for years. And in the last couple of years, we've heard employment lawyers tell us that the public interest disclosure legislation is being misused by employees to try to shoehorn that jurisdiction into their grievance or their complaint to the tribunal because it's automatic unfair dismissal and they don't have to have a year's service. So a lot of people, it's the perception or the reality is that people are abusing the public interest disclosure legislation to get in the door of the tribunal if they've less than a year's service. Okay? Employers will be held vicariously liable for any bullying or harassment that other employees suffer as a result of blowing a whistle, and that's very clear because the legislation in 1988 when it came out didn't make provision for that, but now employers will be held liable. And a bizarre reform, the removal of good faith. So a worker can blow the whistle against their employee if they're motivated by financial gain, revenge, or malice. They can do it. Okay? Their compensation may be reduced by 25%, but it is not a bar to getting them through the door of the industrial tribunal. So that is a significant development. So whilst employers generally welcome the closing of the Parkinson-Sodexo loophole, they were absolutely bewildered to see the removal of the good faith requirement because it effectively allowed people who had bad motive to get in through the door. Okay? So what it seems to give with one hand, it perhaps takes away with the other. Okay? And an anomaly in the legislation that certain categories of health workers who were excluded from the whistleblowing legislation are now to be included in the legislation. Okay? So those are the areas that are changing. Early conciliation already exists in GB. Neutral assessment doesn't exist anywhere else but in Northern Ireland. If any of you are ADR practitioners, you know the construct of early neutral evaluation, very prevalent in the construction trade, not so much in the employment trade, so we're looking very much to see how this develops. Collective redundancy reform is a GB reform and we're mirroring it. Whistleblowing, we're mirroring it. Okay? And in terms of the employment law review, what's happening in the area of 0 hours I talked about briefly, but just to let you know, the focus in the consultation, the 32 questions in the consultation primarily focus on 3 areas. Penalties for people who turn down an offer of work, okay, as a 0 hour worker. So effectively they're penalised and they don't get offered work for maybe 3 weeks later because they've turned it down. Transparency of what the contract actually says, okay, and exclusivity. Okay. The focus in GB has been primarily about outlawing exclusivity. Okay. But as I said earlier on, very few organisations in Northern Ireland that I'm aware of have an exclusivity clause that says the 0 hours worker can only work for us and nobody else because we have trade secrets, confidential information, okay? I think personally it's a distraction. It's a distraction from the 0 hours time bomb, if you want to call it, that might happen. It's only now when austerity measures are happening and 0 hours contractors are being cut that these individuals are coming back and saying, you know what, I've been mislabeled. I'm an employee. Okay? If you ask about the tests of mutuality, if you ask about the tests of control, if you ask about the tests of integration, and you look at economic reality, I am an employee. The practice does not reflect the paper. And cases like Pulse Healthcare, which was a relatively recent case in 2012, said that the tribunal must look beyond the paper and into the practice if it doesn't reflect what's happening. If that is a disingenuous contract because the reality doesn't reflect it. So regardless of how many lawyers have put in boilerplate clauses into the 0 hours contract, if the practice reflects it there, a de facto employee, that's what the tribunal will find. And it found it in 2012 in the Pulse and Healthcare cases. So my personal opinion is, from a practitioner point of view, don't get distracted about the consultation. Audit your own 0 hours practices, because it's when you start to cut these people as a cost-saving measure in these austere times that they'll come back and say, I'm an employee, I'm claiming unfair dismissal. Okay. In terms of agency workers, the Department for Employment and Learning have simply said that they're going to improve the information and guidance. So there aren't any radical reforms. But I can tell you that the trade union movement in Northern Ireland are focusing in on Swedish derogation contracts. Okay? And coming from it from a procurement and a best value angle against HR practitioners. So it would be, for example, if you're sitting in a collective bargaining arena with your trade union and the trade union bring out the code of practice on disclosure and collective bargaining, they'll be perfectly within their wherewithal to point to Roman numeral 3, human resource information, and say, we want to know how many people are on 0 hours contracts, we want to know how many people are on agency workers contracts, and within that, we want to know how many of those agency workers are on Swedish derogation contracts. Okay? So that's the area of focus that you'll find. If you're unionised, the trade unions will be asking this question. Okay? Tubey, I'm not going to talk about because certainly I know John's going to talk about. But the big issue with regard to Tubey in the public sector in Northern Ireland is post-Tubey transfer harmonisation of terms and conditions, especially in local government and people who are moving from central government into local government, and issues about pensions, etc., etc. And the age-old argument or debate about is it Tubey Light, Tubey, or Tubey Plus. Okay, and I know John's going to talk about that. In terms of working time, if anybody asks me a question about the working time regulations now, and it relates to holidays or relates to sickness or whatever, I do not go, as I think I said this last year, deja vu. I don't go to the regulations anymore, I go to the case law. Okay, so the Parita case, the Larner case with regard to people automatically carrying over 4 weeks into the new holiday year without having to exercise it. Okay, the Burr case now with regard to the calculation of overtime. Okay, and remember, overtime clauses. Audit your overtime clauses, and I'm sure Sheena will talk about this, but make sure you audit your overtime clauses. There are 3 standard overtime clauses that are contained normally within contracts of employment or statements of written particulars. The voluntary, the contract, the non-guaranteed overtime, and the compulsory overtime, and sometimes you have like a halfway house between them. Okay? If your overtime clauses fit squarely into the non-guaranteed one, which is what the Burr centred on, it's time to review your practices. Okay, because it will have an impact, and Sheena will talk about that. So the difficulty with working time is it will not move on as a subject until the social partners in Europe get an agreement on the 48-hour opt-out. It is the perennial block on negotiations. So what we have to do at the minute is simply wait for all of these European case decisions to come out, and then effectively what HR practitioners like yourselves have to do is sit down with your senior management team and say, do you know what? We're going to have to look at our employment law risk register with regard to overtime, with regard to long-term sick and holiday pay, with regard to whistleblowing, etc., etc. And unfortunately, that's the way it has to be done. It has to be presented. If you want your senior management team in the organisation to pay attention to these things, you have to present them as a risk register, and do it the same way as you do any risk assessment. Okay? Because that's the only way people will pay attention. It's the only way senior managers will see how HR and keeping on top of employment law developments contributes to the bottom line in the organisation. So learning points. I would make provisions for your relevant statutory rules, particularly around whistleblowing, particularly around the compliance issues with the national minimum wage, and blacklists. Okay, anywhere you have a list of employees who are all union members or activists, etc., you need to be very, very careful about. Think about a dedicated lead person for early conciliation. Okay, it's early days yet, and the bill won't be coming into legislation. We won't have this into legislation until tail end of 2015, early 2016. But it's important to be thinking about these now. Audit and revise aspects of your internal whistleblowing policy. Okay, and as I said, only look at the legislation as a sort of, that's about reactive, and it's about remedies for people who suffer detriment or dismissal. The legislation is not that much use to you. You must think about, from a risk point of view, proactive and preventative, and encourage people to use the internal system. Okay? I'm speaking to more and more public sector employers who are saying to me now, we are now operating what's called a confidential recipient process, where someone from outside the organisation is deemed to be the person who receives the whistleblowing, who feeds back to the employer, rather than the employee going through the grievance procedure, rather than the employee going through a union, rather than the employee raising up with a line manager or SMT. So be aware of this confidential recipient protocol for whistleblowing, because it's becoming more and more common. And with regard to your redundancy policies, or your collective redundancy policies, you need to start thinking about these areas which are still uncertain in the law. Okay? When it's triggered to engage in collective consultation, what is the definition of establishment? And we might know that by Thursday of next week. And what are your consultation protocols? The biggest complaint that trade unions make about collective redundancy consultation is that the 90-day is announced, or the 45-day is announced, and the clock simply ticks down. Okay? And there is not genuine, meaningful consultation with a view to reducing the impact or eliminating these redundancies. Because if it's a parent company in another country that just says it's closing down, it's seen as a fait accompli. Okay? So, lots of work to do. That's me. All right. Thank you very much indeed.